Hello, everybody. So now that we have looked at students' rights involving all kinds of situations, and we did a little bit after that over the last couple of presentations dealing with things such as church and state issues and looking at schools and districts in general. For the last part of the course here, we're going to move in and talk about teachers' rights. Okay, and in order to begin this, we're going to talk about teacher employment and then move into some basic idea of teachers' rights, covering some of the things that we looked at in much larger detail with students, such as uh, the personal appearance, freedom of expression, freedom of religion, those kinds of things. We're going to look at how it impacts teachers, whereas we spent individual presentations with students. We're going to combine all that. So an outline of what we're going to look at here. We're first going to look at teacher certification and why we have teacher certification and how the courts have ruled on that. School boards, the laws giving school boards the authorities that they have and how all of that fits in with teacher employment. Remember, the first part of this is really teacher employment. Contracts, what makes a legal contract. And then finally, we'll sum it up with tenure and how tenure works in the various states. Then we'll move into the rights portion here and look at four areas. We'll spend most of our time on speech and expression, and then we'll look quickly at appearance, privacy, and religion. So let us begin by talking about teacher certification. So in teacher certification, what we can say is pretty straightforward here. Um, because states require students to attend schools, uh, it's no surprise then that the courts have ruled that states can also set rules and laws dealing with the certification of teachers teaching those students. And so therefore, all states now, as a result of No Child Left Behind, before No Child Left Behind, there were some states, I believe, that still did not have teacher certification. In Oklahoma, we've been doing it for many years. Um, so again, in many aspects, you've heard me talk about it in this class and other classes. Oklahoma was kind of ahead of many states when it came to No Child Left Behind because we already required teachers to pass their certification exams. Of course, we've changed the exams back in the day. When I took the exams, between certification for social studies teacher, Spanish teacher, elementary, secondary principal, and a superintendent, I probably took 15 exams. Today, that's combined down to maybe 5. So we're becoming more efficient, I guess. Um, But certification from the state not only requires passing the exam, but obviously having good moral character. We'll talk a little bit more about that. Being a specific age, and being a U.S. citizen, and if not a U.S. citizen, an applicant who has the intentions of being a U.S. citizen. Some states require loyalty oaths to the state and to the federal government. We do in Oklahoma. And then again, for these reasons, it's logical that the State Department has accreditation rights over teacher education programs in colleges and universities. So I don't want to just jump over that last statement and go to the next slide. As a result of the state having the right to require teachers to be certified, then it's a logical step that the state also has a right to accredit teacher ed programs, and it goes beyond just teacher ed programs. It's all programs involving education. So therefore, your school administration program in which you are involved is one of these programs under which the State Department has the authority to accredit it. Now, you've heard us talk about the ELCC standards and how we're accredited nationally. The State Department accepts that accreditation. So if we were not accredited through ELCC, then the State Department would not honor your certificate you're earning through our program. So that's how that works. Continuing on with teacher certification a little bit, some challenges have been made that certification is an attempt to racially, it's a racial attempt to keep races out of the profession, specifically blacks. This has been dismissed by the courts. And finally, when it comes to certification, states can legally deny teacher certification to non-citizens of the United States. And states have the ability to issue non-renewable certificates. The non-renewable certificates would be like what many of you may be actually working on in your provisional. We call them provisional. In the sense of you have a 3-year time limit to complete the specified coursework. Non-renewable certificates are in all kinds of areas. So when we see that Oklahoma has issued over 1,000 emergency certifications, those are typically the non-renewable certificates that require additional training or courses to meet the certification requirements. But the state is going to give you a time period to do that. A lot of times you have this same instance if you were to move to another state. So if you're a certified administrator in Oklahoma, you can go and obtain a position as an administrator in another state and be issued a non-renewable certificate and have a certain amount of time to complete the requirements of that state. So that's a very common practice. States may revoke certification for the following reasons. We're going to talk about this just a little bit more later on, and then in the next presentation when we deal with teacher dismissals. But anytime a teacher violates a state law, false swearing of loyalty oaths, incompetency, child abuse, and immorality, all those things are reasons why the state can withdraw a teaching certificate. And it's either, in Oklahoma, the certificate is usually either withdrawn for 10 years. For example, if you have a felony, if you obtain a felony on your record while you're teaching, your license will be revoked for a 10-year period or for a lifetime. Teachers cannot be dismissed for non-school activities unless the activities can be shown to be detrimental to the conduct of the school. What we're talking about here again is the revocation of your certificate, and this it gets into a little bit of the weeds here when what you're doing as a private citizen, does that have an impact on you as a school teacher, and at what point does that cross the line and has that impact, and the state can punish you for that. So here are some reasons, some general reasons why that could come into play. The likelihood that the conduct may have adversely affected students or fellow teachers. If I knew of an administrator once who was convicted of theft, stealing things from a local Walmart, which was sad because the teacher had the ability to pay for the stuff, and I believe that teacher's license was revoked as a result of that. So it has an impact on the students and fellow teachers in that sense of how it impacted the school and the community. The proximity or remoteness in the time of the conduct. How long ago did this happen? Was it last week? Was it 10 years ago? Was it back when you were young and in college and knew everything except what reality was? A little tongue-in-cheek there. The type of teaching certificate held by the party, extenuating or aggravating circumstances surrounding the conduct, the praiseworthy or blameworthiness of the motives resulting in the conduct, the likelihood of the recurrence of the questioned conduct, and then finally the extent to which disciplinary actions may inflict an adverse impact on the constitutional right of the teacher involved. So lots of things involving outside conduct, non-school activities, and revocation of your teaching certificate. But it does happen. Okay, so don't think that it doesn't happen. Last slide, dealing with revocations and examples. Principal physically assaulting a superintendent. These are all examples out of Alexander and Alexander. A teacher falsifying welfare benefits. It was uncovered that the teacher had received over time a little over $40,000 in welfare benefits, and for that reason, her teaching certificate was revoked. Coaching students on state testing. We've seen that most recently in Atlanta. But obviously, if you are caught giving students the answers or changing test scores, you can lose your teaching license. Accessing pornography on a school computer. We'll talk about that in a little bit later. Privacy. We saw some of that in Oklahoma this semester, unfortunately. Administering corporal punishment by a teacher when policy stated only the principal. There was an example in Alexander and Alexander about a special ed teacher who administered corporal punishment. The policy clearly stated only the principal could do that, and the teacher was dismissed. And then finally, not reporting child abuse, and that's a big issue that we've talked about in previous classes. We haven't really come up against that this class, but it is state law that you must report child abuse if you suspect it. And I had an instance of that when I was an administrator, where we suspected it and reported it, and it turned out to be accurate. And so if you fail to report it, you could lose your teaching license. So real quickly, dealing with school boards and teacher employment. Of course, school boards do a lot more than teacher employment, but specifically dealing with teacher employment, school boards can make rules regarding the following items: additional certification, training, courses, or a degree. A board can put the stipulation in your contract that you will obtain a certain certification or do additional training in order for employment. And if you were not to meet those, you could be dismissed. We typically don't see residency requirements in Oklahoma, but the board can make a requirement that you reside within the district. Typically, where you do see these might be in urban areas. Alexander and Alexander talked about a Chicago case where teachers were leaving Chicago proper and moving to the suburbs. And while they had a residency requirement, it was never enforced until just in the last few years. But those were upheld. Prohibition on outside employment. The board could put that in there as a stipulation. That's perfectly legal. Health and physical standards. Assignment of teaching duties. We'll talk about that a little bit more as well. But the board can assign you teaching duties. The bottom line here is that you might be a certified elementary teacher and a third grade opening is up, and that's your class you really wanted to work in, and you are needed at the sixth grade, and so you are moved to sixth grade. So the board can do that. The administrators can do that under auspices acting under the board. Another example might be if you were hired as a special ed teacher and moved to a classroom where it was shown that that was needed, that could be done. The board can also assign extra duties related to the profession. The courts have ruled this generally does not include driving a bus, crossing guard duties, or janitorial duties. Now, on the surface, especially if you're in a rural school, you may look at that driving the bus and saying, well, you know, when I was administrator, we used to encourage people to get their bus driving license if they needed it, as a coach, especially an academic coach, a cheerleading coach, a band director. Those types of activities may require you to actually get your bus driving license to take your students. That does not mean that you're going to drive the school bus route. Okay? So dealing with contracts, this also falls under the school board, because actually when it comes to teacher employment, it's an agreement between the teacher and the board. And contracts include 5 areas here: an offer and an acceptance. The offer is going to be compensation in the form of money. for teaching, and the acceptance obviously would be an agreement that both parties agree to the terms offered. Competency parties. When we're talking here about teacher employment, the board is the legal body of the school, and that's going to be in policy. And the certified teacher is the other competent party. Consideration, something of value is traded. Here we're talking about salaries given to teachers for this subject knowledge. Legal subject matter, that subject knowledge is going to be the prescribed curriculum within the district. And then finally, in a legal form, and in the sense of teachers, this means a contract that is written and approved by the board in public action and recorded in board minutes. So all of that makes for a contract between the teacher and the board. Now let's move to tenure real quickly before we get into freedoms. Tenure, in short, is legal status provided by teachers who meet certain standards. Usually in Oklahoma, we're talking about time in duty, time in the school district, in other words. What does tenure provide for teachers? And the basic idea here is that without tenure, non-tenured teachers, probationary teachers, in other words, can be dismissed with no cause. Tenure offers teachers due process rights to be dismissed. And reasons for these dismissals include immorality, insubordination, incompetence, misconduct, and neglect of duty. And when we talk about teacher dismissal in the next presentation, we'll lay this out in much more detail. But that's probably the biggest thing on the surface that what tenure does for teachers is it means that in general, teachers simply cannot just be let go at the end of the year. If you're a non-tenured teacher and an administration decides to not renew your contract, you really have no recourse. Supplementary contracts, in other words, for extracurricular duties, are outside of your tenure, and therefore your extracurricular duties can be taken away and assigned freely in a year with no reasons given and no matter your tenure on the job. Okay, so just keep that in mind. One thing I should add here, actually under tenure, is to keep in mind also that in Oklahoma, administrators have no tenure. So you can lose your administration certification in any given time. Or not your certification, you can lose your administration position at any given time in the academic process. Okay. When it comes to a reduction in force, and we've seen rifts in Oklahoma in the last few years with the extreme budget cuts, thanks to our legislatures and governor, district leaders must show financial exigency to make a reduction in force happen. In other words, they need to show that the reduction in force is kind of the last possible thing that could happen. And for that reason, they're going to let go of tenured faculty. If a position is eliminated in a reduction in force or a RIF, the duties of that position cannot be given to another teacher. So here's where boards and administrators have to be careful: is if you do implement a RIF, then sometimes they are done in order to get rid of unwanted tenured teachers. If it's found that you RIF a teacher and those duties that teacher had were assigned to another teacher, then that first teacher can sue and will most likely win because you simply did it to get rid of the teacher as opposed to showing the true financial exigency in order to make it happen. Seniority generally takes priority when it comes to RIF, but that is not always the case. So just keep that in mind as well. Okay, so In other words, when it comes to a reduction in forced tenure, it kind of takes a step back slightly in this scenario. So let's talk about now moving into another area, and that's freedom of speech and expression. And most of this is going to deal with uh, freedom of speech and expression. At the end, we'll talk real quickly about teachers' rights when it comes to religion and privacy and appearance. But most of this dealing with teachers' rights deals with freedoms of speech and expression. So some things to keep in mind here, okay? And it's going to get a little blurry, but hopefully I've kind of organized it here for you, that it makes sense. Teachers are employees of the government. The school is acting as a branch of the government. Obviously, we're talking private or public schools here. Therefore, the teacher is an employee of the government. Okay. Um, so, as teachers are employees of the government, this does not mean that teachers cannot speak out against the school. But there is a special set of laws for employees of the government in the free speech expression. So keep that in mind. It does not mean that you cannot speak out against the government. That would go against the whole idea of what the American government system is about. But there are things that apply specifically to teachers and administrators as a result of the fact that you are an employee of the government or the school. So some basic legal concepts here is to keep in mind, and we're going to go through each of these individually, okay? Teachers do not shed their constitutional rights to freedom of speech. This comes from Tinker, which we looked at under students' rights of speech. It was the first case we looked at. It also applies to teachers back in 1969. There are some questions need to be asked, though, when teachers are involved in speech. Does the speech involve public concern? This was the Pickering case from 1968. Does the speech involve both public and private concern? We're going to talk about the Connick case and see where that gets involved. And then finally, we're going to talk about a much more recent case, Garcetti. Is the speech made pursuant to an employment issue or as a citizen concerning a matter of public concern? And that's an important distinction made in 2006. And then finally, under the Mount Healthy case, is the speech the motivating factor in the board's decision to penalize the teacher? And penalize here, we're probably most likely talking about dismissing the teacher. So let's take each of these in their own right and see how these cases apply to teachers' freedom of speech. So the first one under Tinker, teachers do not shed their rights to freedom of speech. So just like students, the courts have ruled that teachers do not shed these rights. With that in mind, the courts have protected teachers' rights regarding speech. Even so, this does not give teachers carte blanche in what they say. The next step then for consideration is, does this speech involve public concern? And so here we move from Tinker to the next step, and this was the Pickering case of 68. Here the courts ruled that teachers do not have absolute right of free speech, but the state had to show a compelling interest to overcome that right. In other words, the state, and every time I say the state here, I mean the school district. The districts has to show a compelling interest that what the teacher is saying is having a negative impact on the school. And if that's the case, then the school can start to limit that, even though it might be a public concern. In Pickering, and this is the actual case, a teacher sent a letter to a newspaper against a proposed tax increase by the Board of Education. And as a result, the teacher was dismissed. The court ruled in favor of the teacher, though, and stated that the tax increase was, in general, a public concern. And therefore, as a public citizen, the tax increase had more of an impact as a citizen than it did as an employee, and therefore the courts ruled in favor of the teacher here. So the teacher had the freedom, the right to express his or her disapproval of this proposed tax increase. So then the next step in the case brings in Connick, the case of Connick. This case came to the court in 1983, so it's a little bit later than Pickering and Tinker in 68 and 69. But again, like I said, what we see in court cases is just further clarification. So here we see the First Amendment protections are guaranteed for public speech, but not for private speech. When it comes to education, this can be a fine line when what is in the question of what is public and what is private. So Connick and Pickering then are going to be combined to form this two-step process. The first question, is this speech public, a public concern involving political or social items? If not, then the government enjoys more latitude in management of the speech. If it is public concern, then the government kind of has to step back on this, the schools, in other words. That's Connick. So the second part of this test, if the speech is public, the courts have to balance between matters of the employee as a citizen versus the interests of the district to promote effective and efficient public service. This is the Pickering case. So if the speech is public concern, then the district really doesn't have a lot to say so. If it is, though, where the district might come in, is that balance between the matters of the teacher or the employee of the school as a citizen versus the interests of the district. So in other words, here's an example. The district can restrict speech that addresses a matter of the effective running of the school. In other words, here are some examples from Kern, a teacher speaking at a board meeting regarding tenure of another teacher, and teachers writing a letter to the State Department concerning the district's use of federal dollars. These are instances where the courts had ruled in favor of the district, stating that even though these were public concerns, the interests of the district outweighed those of the citizen. Does the speech involve both public and private speech? Again, speech test for a public employee is summarized as below. So what's the difference between that public and private speech item? Public speech is a fundamental right of teachers to exercise. In order to restrict that right, the burden of proof is on the board. Public speech can be denied if the interest of the district outweighs the interest of the employees in the exercise of that right. Public speech involving matters of public concern denial means that the board must clearly show there is a substantial interference that would or did occur as a result. And speech involving private concerns requires relatively low standards of proof by the board to dismiss a teacher. This speech can be considered to undermine the authority, disrupt the decorum, or harm working relationships. So you can see that according to Connick and Pickering, there is a way to limit that public speech of teachers, but it's really the burden of proof is on the district, specifically the school board, to show that the interests of the school outweigh those interests of that teacher. And that's going to be a hard one to prove. When it comes to private concerns, though, the burden of proof is relatively low for the teacher. So the next step then in the speech debate is the speech made pursuant to an employment issue or as a citizen concerning the matter of public concern. So in 2006, the court brought in the pursuant to duty test with the Garcetti case. This means that employees do not have unfettered freedom of speech to speak out on matters of internal consequences and conduct of their public employment. So as a teacher, if you're making a speech pursuant to duty of you as a teacher, and it may be public concern, but this is we're going to see restrictions on that here. And again, we're going to look at this balance between the interests of the district and the interests of employees or teachers. The exercise of speech by a public office employee about policies or activities of the public office are subject to public employer control. So here what we're saying is speech by teachers about policies or activities of the district are actually subject to district control. School administrators and teachers are advised not to publicly criticize school policy in a way that could be detrimental to the operations of the school. Some more examples from Garcetti. Public concern, for example, speech regarding school officials' misdeeds and impropriety. If you find something going on in the district that could be construed as a misdeed, you're certainly welcome to discuss that. Things that are not public concern, you, in pursuant of your duty as a teacher, complaining about a principal, complaining a lack of teacher aides, complaining about the teacher workload, the staffing levels, all of these things are not public concern. Therefore, if you make a speech, what we're saying here is if you make a speech about these items publicly, because they are not considered public concern, then the district has the ability to reprimand you for that in a way it seems fit. A couple of examples from your textbook. There was a coach in Dallas ISD fired by complaining about entrance fee that was not paid by the administrator to a sporting event for an athletic team. And then, of course, the other one in there that's an easy one, the principal physically fighting with the superintendent about funding for. So I don't know if that one was physical. There was another one that was physical. This one here, though, a principal arguing with the superintendent, fighting about school funding, and took it to the public, and as a result was dismissed, and that was upheld. The last standard then under freedom of speech is the Mount Healthy criteria, and this involves the motivating factors for the decision of the board to penalize a teacher. If the speech has both constitutional and non-constitutional issues, the court has ruled that motivating factors must be examined. So in other words, the speech that the teachers have uttered may have some public concern in it that are protected, may have other public concerns that are not protected, may have private concerns. As a result, the teacher is dismissed or the teacher is reprimanded. The court is saying under this case of Mount Healthy that the motivating factors for the reprimand have to be examined. And the example used in your book was that a teacher complained about an appearance policy. I'm assuming that means a dress code in the school. Unfortunately for this teacher, the teacher had had previous altercations with another teacher, had argued with cafeteria employees, had sweared at students, and had made obscene gestures to female students. The local phone call to, or the phone call to the local station may have been the camel that broke the straw's back. The teacher was dismissed. The courts looked into this and said the motivating factors overall in the big picture was that this teacher was not doing the teacher's duty. I forget what the technical phrasing was the district used to refer to that, but the courts ruled in favor of the district, and the teacher could not show here that the free speech exercise of complaining about the policy was a motivating factor for his dismissal in order for him to prevail. So the last thing here then for speech overall is speech made pursuant to an employment issue or as a citizen concerning a public matter. And this goes back to the Garcetti case. So here we need to just look at some examples, some brief examples. Private speech. A teacher's rights are protected in private speech with school officials. If you have a discussion with your principal, organize it as a private meeting between you and the principal, then you have the expectation that your speech is protected. Political activity. Teachers cannot be involved in political activities which disrupt the educational process. Teacher cannot use his or her position to promote a political agenda. I once walked into a classroom and saw that the teacher had written on the board, if you live in America, you should speak English. Well, that was obviously a hot political button, and I brought it to the attention of the administrator, and the teacher removed that from the whiteboard. But that could have been an issue for reprimand, actually, bringing in that kind of political activity. Teachers cannot wear political slogans, those kinds of things, on school grounds. Again, you are working for the state, and we've talked a little bit about this in the past. Retaliation. Employees are protected from retaliation in the exercise of their free speech. If you feel that you've been retaliated against for doing something that was perfectly legal, then you would most likely have a case against the district for that. Curricular speech. Teacher curricular speech is considered public concern and pursuant to duty. Therefore, when you publicly talk about and criticize the curriculum, that can be reprimanded. So just keep that in mind. Typically, it depends on the size of your school district, whether we're talking about a district curriculum versus the state curriculum, which if you take curriculum development, you'll learn that what we quite often call the state curriculum is not a curriculum. But nonetheless, that's reality for many smaller districts. And then finally, political office. States have rules on teachers holding political office while teaching. Oklahoma says no. If you run for political office and you take a seat in the Senate or the House in January, when you do that, you must relinquish your position as a teacher or an employee. So a lot of involvement there dealing with speech and whether the speech is public, and then even at that point, how much the interests of the school outweigh that speech and whether or not it can be halted or a teacher can be reprimanded for that speech. These are just a few extra things on the end. So let's wrap it up by looking at a few other teachers' rights. Questions about appearance and dress codes. Simple here. Boards have the ability to address faculty dress codes. So that's not an issue. It shouldn't be. This could include grooming. So keep that in mind. Privacy. Teachers can expect similar rights of privacy as students do. Not included as a private item would be your vehicle if it's parked on school property, your desks, computers, and phones. If they are school owned, then anything you do on that computer or that phone can be viewed by the district without permission. And finally, the last thing comes to religion. Teachers obviously have the right to their own religious beliefs, but cannot impart these to students. The main thing here under religion would be two things. Teachers taking days off for religious observances. They can be required to take personal days to do that. The other thing, probably more so in Oklahoma as being a very conservative state, is teachers teaching the curriculum, which includes evolution and does not include other items such as intelligent design. And so teachers must teach the curriculum as it is approved by the state, and cannot say that they will not teach it due to their religious beliefs. Otherwise, they could lose their job as a result of that. So hopefully that's a nice little introduction to teacher employment and some basic rights that teachers have.